Hello, and thank you for attending our training. Today we will be talking about the Administrative Law Judge Code of Conduct. My name is Kim Weber, and I am the Executive Director of the West Virginia Ethics Commission. And today you'll hear from me and from John Roush, who is our General Counsel, and from John Ellem, who is our Deputy General Counsel. And we'll be covering several topics today. And on this screen, you can see what we'll be touching on today. We're going to begin with Mr. Roush, and Mr. Roush is going to tell us to whom the ALJ Code of Conduct applies. And then Mr. Ellem will take over, and he will explain the Ethics Commission's role in enforcing and interpreting the ALJ Code of Conduct. Then you'll hear more from Mr. Roush, and he will talk about some specific duties that ALJs owe, including independence, avoidance of the appearance of impropriety, and the rules of decorum. Mr. Ellem will then take the stand, and he will talk about prohibited political activities and restrictions on the outside practice of law. And finally, you'll hear from me, and I will talk about the Ethics Act and how the Ethics Act interplays with the Administrative Law Judge Code of Conduct, and I will touch on some other outside employment limitations. So with that, I will turn it over to Mr. Roush.
Thank you, Kim. The first question anyone watching this video must ask is, does the Administrative Law Judge Code of Conduct apply to me? The answer to that is not as simple as it ought to be, I suspect. Let's look at the Administrative Law Judge Code of Conduct and what it says about what it takes to be an administrative law judge. A couple takeaways here. First, basically that usually an individual who's an administrative law judge and subject to the Code of Conduct must work for the state government. Now, there is a bit of a twist there, and we'll talk about that in a little bit. Second takeaway, though, is what an administrative law judge does. And that is someone who exercises independent and impartial judgment. They conduct hearings in contested cases, and they issue recommended decisions or reports that contain findings of fact and conclusions of law in accordance with applicable statutes or rules. Let's go ahead and look at the definition in the West Virginia Code. It's very, very, very similar. Same type of thing. You have to be employed by state government, and you have to be someone who actually has a role presiding over a contested hearing and makes a decision based on the findings of fact and conclusions of law. Let's take a look closer at this question of what you do. As I said earlier, it just simply isn't enough that you're either called an administrative law judge as your job title or that you're not called an administrative law judge. It's not so important what you're called. It's what you actually do. To prove that, the Committee on the Administrative Law Judge Code of Conduct has issued a number of advisory opinions, and there are two here that I think illustrate perfectly the concept that the title isn't quite the end all of whether you are subject to the ALJ Code of Conduct. First one is ALJ-AO 2012-02, and that involved an individual who had the title of grievance evaluator and worked as a hearing examiner. However, that person was held to be an administrative law judge and subject to the code because of what that person did. He or she presided over administrative hearings. They were contested. He or she drafted and made decisions on these contested matters and issued decisions based upon findings of fact and conclusions of law. More or less what the Code of Conduct and West Virginia Code says that an administrative law judge does. The other side of the coin is illustrated by Administrative Law Judge Advisory Opinion 2008-01. In that situation, an individual actually had the title and was paid as an administrative law judge. However, that individual did not preside over contested hearings, did not issue decisions. What that individual did was that they conducted mediations and tried to help parties get together. That it doesn't fall under the description of what an administrative law judge does. So even though this individual was called an ALJ, he or she was held not to be subject to the code of conduct. Now, you remember I said to you that there was a little bit of a twist on the fact that to be an ALJ and to be subject to the code of conduct, you had to work for a state agency. In the spring of 2023, the legislature amended the Public Employees Grievance Board Act, I suppose is how you would put it. And it indicated that not only administrative law judges, but chief administrators involved in the public employees grievance procedure were to be subject to the code of conduct for administrative law judges. Now, the administrative law judges worked for a state agency, so there was no question. They were already covered. Chief administrators is a different matter. If you look at a different part of the Public Employees Grievance Board procedure law, you'll see that a chief administrator not only means the head of state agencies and things of that nature, but also the head of county boards of education, the county superintendent. Further, involved in the definition of chief administrator, which is a title that is covered by the ALJ Code of Conduct, is anyone who is delegated or appointed to serve as the chief administrator's representative at conducting level 1 hearings and level 1 conferences. So now we have people who do not work for the state, but they are involved in the Public Employees Grievance Procedure who are covered by the Administrative Law Judge Code of Conduct, which by estimation probably doubles the number of people who are actually covered by the Code of Conduct. All right. At this point, I'm going to pass the ball over to John Ellem, who will tell us a little bit about what the West Virginia Ethics Commission does, or what their involvement is in the Administrative Law Judge Code of Conduct.
Thank you, John. Yes, what is our involvement as an ethics commission and agency of government? Next slide. So we are involved in interpreting and enforcing the ALJ Code of Conduct. This could mean providing informal advice, whether that be a written email, for instance, or a phone call. We also have the subcommittee or the committee on the standards of conduct for administrative law judges that investigates complaints or can issue a formal advisory opinion. And of course, those are heard by the committee and are issued in writing and put on our webpage, as opposed to written informal advice, which we just send to you directly, or as opposed to a phone call. Now, the remaining members of the Ethics Commission that are not serving on the Committee of Standards, they will be the ones to actually hear any contested cases involving alleged violations of the Code of Conduct and then issue a final decision. Next question. Next slide, I should say. And the process that we go through for complaints starts with a verified complaint. Unlike many instances in civil proceedings with civil complaints that aren't required to always be verified, we do require verified complaints. And again, the committee of the subcommittee, if you will, of the Ethics Commission on the Code of Conduct then access the investigative panel. They review that complaint that's been filed for sufficiency. In other words, is there a jurisdiction for the complaint? For instance, if somebody loses a hearing, files a complaint against the judge saying they're biased because they were a graduate of the University of Pittsburgh Law School, that's probably, without more facts, not going to be sufficient to proceed any further. Contrast that to maybe where somebody files a complaint against an administrative law judge saying that the key witness against them they later learned turned out to be the mother of the administrative law judge, which may then proceed on to the next stage, which is a notice of investigation being issued by that committee on standards. Those notices are then investigated, by staff, and the panel ultimately has to determine if probable cause exists. And if not, of course, it's dismissed. If probable cause exists, then it proceeds to have a hearing date scheduled where you go through the discovery process. And at any point along this line here, you'll see in the yellow star, a conciliation agreement can be negotiated between the commission and the person that's the subject of the complaint. And that's a form of alternative resolution without need for a full hearing. Next slide. So again, the members of the Ethics Commission that were not on the panel will be comprising the hearing board, and they will hire a hearing examiner to conduct the hearing pursuant to the West Virginia Rules of Evidence. Staff of the commission, such as myself, will serve to prosecute the case. And then once the hearing is held, there's a process, as you can see, for written briefs to be submitted and a recommended decision being made by the hearing examiner in 45 days. And now the final ruling can then be appealed directly to the West Virginia Intermediate Court of Appeals under the Administrative Procedures Act. It does not go to circuit court. Next slide. So exactly what does the administrative law judge code of conduct require of an ALJ? Next slide. An ALJ must maintain the integrity of the administrative judiciary. So what is integrity? As we parsed through the code of conduct, these three themes along the left side came up and I think really illustrate what it means to maintain your integrity. Professional competence, maintaining decorum, and we'll discuss what decorum means here in a second, and your judicial demeanor. Next slide. So, of course, for professional competence, an administrative law judge has to be faithful to the law and be competent in it. Now, an ALJ can consult with other colleagues to learn information or ask legal questions. Also, another tool to keep in mind, maybe put in your toolkit, is that you can also consult with your own experts if you go through the proper disclosure procedures, which I thought was interesting. So if you want some additional information and you put the parties on proper notice as set forth in the code, you can consult your own independent expert, and of course, staff and other members within your control. Next slide. Maintaining decorum in proceedings. I didn't realize that one spun, but as you can see, that the physical slap is certainly something else as opposed to maintaining decorum. Decorum, I found that the best definition that I found of that came from Cambridge Dictionary. Decorum, they defined as being behavior that is controlled, calm, and polite. So I think that's a pretty good sum in just 3 or 4 words of what decorum is. Next slide. So this duty of decorum is not just limited to the administrative law judge himself or herself, but it has to be applied to anybody participating in the proceeding. And of course, the administrative law judge, this I think goes without saying, is going to make sure that the parties avoid any type of bias, prejudice based on race, gender, all these things we commonly know as lawyers as protected categories. And this includes any of this conduct to a witness, to any parties, of course, to the lawyers that may be involved in the proceeding, or anybody else. Next slide. Judicial demeanor, very closely related to decorum, courteous to litigants, lawyers, witnesses and anybody else the judge deals with in an official capacity, and requires similar conduct of lawyers, the judge's own staff members, or anybody else for that matter that is subject to the administrative law judge's direction or control. So it's an encompassing requirement, and not just this whole idea of demeanor and decorum is not just limited to the administrative law judge, but really to all parties involved in the proceeding. Next slide. And this is probably a little more timely. This has been a matter that's been recently dealt with, I think, by our Supreme Court, where care has to be taken not to make any type of public comment that could affect in any way the outcome of a proceeding, as well as its fairness, or any non-public comment for that matter that could interfere with the proceeding. And this requirement extends not only from the judge, but again to those under the control of the judge, the part of the agency personnel that the judge has direction and control over. Next slide. The Code of Conduct also requires independence and faithfulness to the law. So you cannot be swayed by partisan interests, public clamor, employment status, or fear of criticism. In today's modern age, that would certainly include social media posts, which are, all too common ways of, is a common way of making comments, and cannot be allowed to influence how you conduct the hearing or how you make your ruling. Employment status, I guess for lack of a better term, being a homer for the agency. Again, that goes back to independence, as opposed to being somebody that is believed to have been always ruling in favor of the agency that they're working before. And the next slide, I think I'm going to turn it over at this time to Ms. Weber.
Actually, to me, John.
I'm sorry.
Well, the Administrative Law Judge Code of Conduct requires an ALJ may be impartial. That's one of those noble aspirations, but I have to hand it to the people who wrote this up. Essentially, they did provide some very practical tools that you can use to try to gain or have the appearance anyway of impartiality. There are three of them, and three main ones anyway. First is the self-disqualification requirements. Then there are the disclosure requirements, and then there's just avoidance of suspicious financial details and dealings. Let's talk about self-disqualification first. The Code of Conduct requires a ALJ to disqualify themselves in certain circumstances, and I want to be very, very clear here. We're not talking about an ALJ who offers to disqualify themselves. If any of these factors exist, the judge must, on his own initiative, disqualify himself. And that can be dealt with a little bit. We'll talk about in a minute. But first off, let's look at the areas where a judge must disqualify himself. First, if they have a personal bias against a party or a representative. That's obvious. One thing I do want to mention, though, that has been more or less in an unofficial way viewed not only as just negative bias, but also positive bias. For example, an ALJ asked, or a prospective one who became an ALJ asked whether he or she should leave, or I should say disqualify themselves from certain kinds of hearing. This individual had been an advocate for a major labor organization, and he foresaw that some of his past clients, some of the representatives he had worked with, might come before him, and that was held to be something that required him to, first off, always disclose what his past was, who he had used to work for, and then when he had a former client come before him, to disqualify himself, be one of the representatives representing someone involved in the situation with somebody he had worked with as a colleague. He would need to recuse himself. So, in any event, There are other reasons too. For example, if the ALJ actually acted as an attorney or was associated with another attorney who did so in an earlier step of the proceeding that eventually landed before him as an ALJ, they would have to recuse themselves. Now, I might mention the association with another attorney usually means somebody that you're practicing with or in your firm. Usually, if you are just an attorney for an agency and somebody else is also an attorney for an agency, that isn't normally enough to be an association that would require you to recuse yourself. But again, in situations like that, it's always best to give us a call and talk to us about it. Now, if you have a financial interest in the matter, you're supposed to disqualify yourself. That's pretty obvious. If you have family involved in the case as a party, a witness, or an advocate, that is another reason. I think John had mentioned that situation a little bit earlier in our presentation. We've had at least two situations, one where a judge basically had a witness was going to be there, not a party to the party, but a witness was going to be there, and who was going to be his son, and that was held to be something that he should recuse himself from. Another situation, an individual, your sister, was a representative who was going to be representing one of the parties who appeared, and that was held to be a situation where he really needed, or she or he really needed to recuse themselves. Finally, the question is, judge knows he or she is likely to be a material witness in the proceeding. That material witness, that's someone who actually witnesses what happens, is not somebody who comes in and identifies a policy or a piece of evidence or certifies that the record is there. Someone who's going to be a material witness at any stage, either before the ALJ or at a later stage. That person really needs to disqualify themselves. Now, go to the next. The second tool to maintaining impartiality is disclosure. Now, the code of conduct clearly indicates that except for the reason of disqualification of personal bias against or for a party or representative, an ALJ can offer to remit his disqualification and go ahead and rehear the matter. What has to happen for this to work is the ALJ needs to disclose the basis for the disqualification. Then, independently of the ALJ, the parties and the lawyer representatives agree that the ALJ should not be disqualified. In other words, they think, we don't think you're really going to be biased here. And then after all that, the ALJ, he or she, must be willing to go ahead and retake the case. Another key point here, though, the ALJ does not offer to recuse themselves. They make the recusal. The offer is to undo it, to remit the disqualification. Now, avoidance of suspicious financial dealings. Obviously, an ALJ should try to avoid the type of investments and side business and things of that nature that may be perfectly legal, but may, in fact, in the public's mind or in reality, affect his ability to look at situations come before him and be impartial, basically. Secondly, the administrative law judge has a positive requirement. It is put upon he or she to be aware of what their personal and fiduciary and financial interests are and what those are of their immediate family. So an ALJ can't really come back and use the old George Costanza defense and say, I had no idea that my wife was CEO of that company. So it's put on you. You have an obligation. Independence, another high ideal, but as I say, the people who put this code of conduct together really tried to be helpful. They gave you factors that you could use and follow in order to maintain independence. Let's look at them. First off, the judge may not be compensated on the basis of the outcome of the case. In other words, for example, if you're contracted to hear grievances, you can't be paid $1,000 for granting a grievance and $500 for turning it down. It has to be, like I say, there can't be that kind of incentive to rule one way or the other. You can't be supervised by an individual who has been an investigator, prosecutor, or an advocate before you. And that kind of troubled me. What difference does that make? Well, the point is, some people, I think you can see their future and know that they're going to be become a chief administrative law judge, or possibly be the head of an agency where they deal with, these type of contested cases. And given that possibility, they want to remove that from the ALJ, that they might be trying to butter that person up ahead of time by treating them more favorably in the hearings here now. Maybe it'll go better for me if he or she becomes my supervisor. So that makes sense when you think about it a little bit. Finally, the administrative law judge cannot be subject to undue or improper influence of the head of the agency or whose decision is at issue. And that's particularly important because a lot of ALJs are actually hired by and employed by the agency that has a benefit in or has a stake in the outcome. Therefore, the Administrative Law Judge Code of Conduct says very clearly that the fact that ALJ rules in favor of an agency by which he or she is employed does not in and of itself demonstrate a lack of independence, basically. Secondly, I mean, it also indicates in various places or in the Administrative Law Judge Code of Conduct advisory opinions that the fact that the agency who's involved or is a party actually provides the person the file, does clerical work, sets up the hearing, things that isn't enough to really challenge the independence of the administrative law judge. Big thing. Administrative law judge, and we're going to say this 2 or 3 times, should avoid not only impropriety, but the appearance of impropriety in all activities. And that's kind of code for on the job and off the job. You really need to be careful with what you do with your life when it comes down to it. If you're an administrative law judge, you're held to a higher standard. Which leads us to one key takeaway here. If there's anything that you are required to avoid as an administrative law judge, you really should try to avoid the appearance of doing. So, a good example of avoiding appearance. In an advisory opinion from 2011-01, it was held that it would give the appearance of partiality if an administrative law judge actually rode in the same car to a hearing site with members of an agency who were a party. I think this must have been during one of those times when the price of gas wasn't quite so high. Maybe there'd been a little more ease put on this particular rule. Another thing, and this is good practice. I mean, I'm sure the judges of the ALJs understand to do this, but it's another thing where it can give a possible appearance of having partiality, and that is ex parte communication. Now, it isn't completely banned. I mean, the judge can, in fact, speak with the parties outside the presence of the other to do logistical things, set up a hearing, try to get hearing dates, things of that nature. But anything that might give one side or the other an advantage in the substance of the case or in the procedures of the case should be avoided. Finally, a little bit of food for thought. If there's anything in the ALJ Code of Conduct that says that you should restrict the amount of conferences you have with just the representatives. And what I'm talking about, a situation where the ALJ says, the parties, the lay people go out of the room. I want to talk with just the representatives of the attorneys. Nothing there says that. But it really does give the appearance of unfairness. It really bothers lay people. They don't understand why they're being excluded from their case. Nothing in there. I think it's a good idea. So we'll try to avoid that. I know there are times when you have to do it, but to the extent you can, try not to have those conferences with the parties, the grievant and the superintendent or the claimant and the employing company. Try not to have conferences with those people excluded and you're just talking to representatives. It really does anger and confuse those folks. Administrative law judge shall not hold membership in any organization that practices invidious discrimination on the basis of race, gender, religion, and national origin. And this, again, is conduct outside the job, basically. Code of conduct, though, does kind of soften that a little bit. It says that excludes from that groups that for preservation of religious, ethnic, historical, or cultural values that are legitimate, covered by constitutional protections. That doesn't count. How the heck do we make any kind of sense out of that? Well, I think you just really have to be common sense rule. I mean, what this means is probably being a member of the Daughters of the American Revolution is okay. Being a member of the National Socialist Party of America probably isn't. So, just have to have common sense. And a word to the wise here, since I'm the oldest person in this trio, you should be aware that what's okay in 1980 probably isn't okay in 2020, and what's okay in 2020 may not be okay in 2035. So be aware and try to be to be up with the times as far as at least not offending people, and whether it's politically correct or not offending people is a real goal that we all ought to be aiming for. Again, second or third time said it. If there is something you do that could be a source of controversy or embarrassment or bringing shame on you or your agency or whatever, just don't do it. Okay, at this point, I'm going to pass the microphone, so to speak, over to John Ellem, who will talk to us about what sort of political activity that a state administrative law judge, or at least a full-time one anyway, should avoid. John?
Thank you, John, and great discussion. And along the lines of just don't do it, we'll get into some more of those during my presentation, beginning with, first of all, political activity. So you have to refrain from any political activity that is inappropriate to the office. Well, what does that mean? We're going to discuss that in this upcoming slides, and keep in the back of your mind, or I should say maybe at the top of your mind, that a distinction between full-time ALJs and part-time ALJs. That's an important distinction as we go through these next slides. Next slide, please. Does the Administrative Law Judge Code or the West Virginia Ethics Act affect what I may do off the job? Next slide. A full-time ALJ may not serve as an ALJ and run for elected office. So you can run just as long as you're not running for office. Next slide. So before if you're a full-time administrative law judge and you do have that hankering to run for office, then you need to a political elected office, and you need to resign from the office or take and approve the leave of absence prior to becoming a candidate in either the primary or, for that matter, the general election. Now, there's a key distinction there. Next slide. When are you a candidate? Well, it is not when you sign the official form to register to run for office for purposes of the Code of Conduct, but you in fact become a candidate for an elected public office as soon as you make that announcement of your candidacy, or if you don't make the announcement, then of course once you file as a candidate with the appropriate office, again, or you solicit or accept contributions or support. Of course, you shouldn't be doing that probably until you actually file for office. But again, if you decide to hold an official announcement at a local hotel, for instance, to announce your candidacy, even though you haven't officially yet filed, you need to be aware that now, for purposes of the Code of Conduct, you have become a candidate by having that special announcement. Next slide. And then again, sticking with our theme of full-time administrative law judges, you are not able to personally solicit funds for another candidate, a political candidate, or for a political organization. Next slide. Key little note to keep in mind here is that the agency that you are working for or before may have their own code of conduct that can supersede what we just went over. Now, to do this, they have to give the Ethics Commission a copy of that code of conduct, and it has to comply with the objectives of the actual rule, and we have to grant a waiver for the agency to do their own code of conduct in accordance with the requirements. And then, in fact, that agency's own code of conduct has to be made available by us to the public. And I think we looked through that. Correct me if I'm wrong, but to our knowledge, I don't believe anybody has done that. No agency has yet to do such a thing, but it is out there. Next slide. An administrative law judge has to, again, there's those words, avoid the appearance of impropriety in all activities and comply with the law, respect for the law, and act, again, at all times in a manner consistent with public confidence and integrity, which we talked about earlier, and impartiality of the administrative law judge's office. Again, we've highlighted the key words: all times, all activities. So the word all is critical under this rule. You got to be mindful, so to speak. That's a common word we hear a lot today in society, being mindful of what you do. And I think this certainly applies here when you take that important position of public trust. Next slide. So we've talked a lot about what an administrative law judge cannot do, what you have to be on the lookout for and be concerned about, and what you have to avoid doing. So we'll turn here to a little more positive note. What can you do as an administrative law judge? Many good things. Teach, write on your expertise, your area of law that you're an expert on, or other topics. Any group that would advocate improvement of the law. You can appear at governmental hearings if they're related, again, to advancing the law, whether that may be a legislative interim committee that's meeting and looking to, refine or update some code provisions, things of that nature. Of course, any hobbies, small occupation, your own callings, of course, as long as they're not inconsistent with the integrity of the office, are allowed. Civic charitable activities, serving as an arbitrator in a proceeding, and then, of course, the big one for most people, practicing law yourself. So let's go to the next slide. When you are engaged in the practice of law, you have to keep in mind certain conflicts. I think most of these are self-explanatory or make just good common sense, and that we deal with as practicing lawyers quite often too. You can't represent somebody who appeared before you in the preceding 12 months. If it's going to undertake, if you'll be undertaking representation of a client where the matter could involve your agency, then that representation cannot be undertaken. You cannot practice before an agency which you yourself are likely to appear before. Of course, you can't sue or take advocacy against the state on behalf of a client. And when you're using your office, administrative law judge office, you cannot use office equipment or supplies for your own private practice, which is a big issue, use of public office for private gain that we see under the Ethics Act. Now, you see the de minimis exception in there. I'm not going to go into that in detail, but if a pen from your agency's office happens to make it into your briefcase, well, that would probably be de minimis. But if you're using their mailing equipment or stamps and all their office paper and copiers and so forth, then you may be going beyond de minimis and using public office for private gain. And again, along those lines, don't do your private practice while you're actually working on agency work time. Next slide. Further restrictions, again, private use of public office for private gain. You can't use subordinates. There's such thing as volunteering, and you must recuse yourself or from any cases involving an attorney that you practiced with or against in the last 2 years, or if you have referred or received referrals from that attorney in the last 2 years, and recuse yourself from cases involving a former or present client. And you may not be allowed to have private practice, allow your private practice to take control and precedence over your duties as an administrative law judge. So you have a duty there to maintain an appropriate level of private practice. I'll give you a citation where we got a lot of these items from part 1 and part 2 that came from an advisory opinion that was issued by that committee on standards that we talked about when I first spoke. That is advisory opinion 2007-1, and that can be found on our website. 2007 indicates the year that the opinion was issued, and the 01 means it was the first opinion issued that year. Also, for cases involving matters involving prior clients, another advisory opinion I'll give you a cite to is 2019-1-R if you get an issue and want to learn more or study more up on that type of situation.